I think what I have found hardest over the last 2 years when speaking to my clients in relation to the plural plaques issue and the judicial review that's been ongoing over that time is to try to explain to them that in the eyes of the law, the insurance companies who have withheld their compensation for as long as 5 and 6 years now are deemed to have a greater interest in this legislation than they themselves, the victims of asbestos disease. And that simply defies common sense, never mind natural justice. Thompsons had to fight to become party to the judicial review on behalf of our clients, and we had to keep on fighting right through to the Supreme Court to maintain our right to be there. And we are, of course, delighted that that fight has been vindicated. The essence of this decision is that the entitlement to defend and to challenge legislative and administrative decisions has been widened enormously. And whereas previously the Scottish courts have taken a very restrictive approach in assessing who is entitled to raise these challenges, they have adopted an approach based on a private law concept of title and interest. And the Supreme Court have found and said unequivocally that a private law concept has no place in public law matters. And the correct test should in fact be one of standing, and standing should be determined by being able to demonstrate that there is an interest, a general interest in the issues which are being challenged or brought into question. And if you look at that in terms of the wording of the court rules in relation to judicial review, the test there is one of being directly affected, which lines up nicely with the Supreme Court's concept of having a general interest. It opens up huge possibilities for NGOs, for trade unions, charities, campaign groups to raise challenges to legislation on the part of their members. And what it also does is bring the Scottish position much more in line with what the approach in England has been. It seems more than likely that there will be a surge in public interest judicial review because of the nature of the groups who will now consider themselves to have standing to raise these challenges.